Welcome to Dementia-Friendly Prince George's County, Maryland, Northern Sector webinar series for caregivers. Today's topic is Generational Legacy Planning by James Henderson, sponsored by Prince George's County Government and Department of Family Services.
I'm glad you're here tonight to hear what we're talking about. It is about estate planning. Why now? After all, it could be argued there's nothing new about estate planning. It's been around since the laws governing property ownership were created. We take these laws for granted today, but they're very important. They protect your right to own certain property, not worry about someone else, your neighbor, or the government taking it away. When you have ownership rights, depending on the type of property, you can enjoy it for your own use. You could sell it or you could give it away. When you die, ownership would be transferred to another individual or entity according to the laws of succession. For example, to a spouse or a child. Then that person has full ownership rights. I just saw another instance about the Gullah population in the Carolinas, where the developers are coming to try to take the property away from the people who had air property. And the reason why there is air property is because of the lack of estate planning. The laws of succession governing the transfer of property at death are clear and specific, even though we may not always know what they are. For example, in some states, everything owned by one spouse automatically goes to the other spouse. In other states, it is split between spouse and children. So estate planning really starts with knowing what the laws are in the state where you live. Then you can decide if you want to take the law into your own hands, so to speak, by drafting a will or a trust to name the people you want to receive your property after you die. But estate planning involves so much more than wills and trusts. How you hold title to the property in the first place can have repercussions both while you're alive and after you die. And what about your IRA? Most people sign that IRA beneficiary designation forms without giving much thought to it. But these forms are powerful estate planning tools and need to be coordinated with the rest of your estate plan. The point is that the laws governing property ownership and property transfer are very complicated, and you need to know how they will affect you and your family if you die tomorrow. If you will want to override these laws in some way, which most people do, in order to make things easier on their family, you need to get the proper legal documents drawn up. We call this getting your affairs in order. And everyone needs to do this because what we will cover in today's presentation is not legal advice. So you have to speak to an estate planning attorney and for more details. I have two practices. One of my practices is a tax consultant, and I also do financial planning. And so part of estate planning is putting all of my clients' affairs in order. If we learn anything from the coronavirus, it's that anything can happen to anyone at any time, even in normal times. The news is filled with stories about accidents, natural disasters, sudden illnesses, and other unexpected events that upend people's lives. And then there's the biggest mystery of all, actually the fact that death is really is predictable. We all will die at some point. We just don't know when. None of us are going to be able to make it out of here alive. But the timing is unusually unpredictable. That's why we need to get our affairs in order so you'll be ready when it happens. Because the laws governing property ownership and property transfer are intangible, it's easy to ignore them. But death is a legal event. Let me say that again. Death is a legal event. Once a person dies, these laws that come into play, and they determine what will happen to your assets and your possessions, that is. Who has the legal owners, who they will be. And if you have done your estate planning, you can live the rest of your life knowing that when your time comes, your loved ones will have the law on their side because you have set it up that way. Because estate planning is so important, I like to spend a few minutes talking about what could happen if there is no estate plan. If you're unfamiliar with some of the laws that could affect you and your family, this could be your wake-up time. Let's say you get into a car accident or have a stroke and couldn't communicate with medical personnel about your treatment options. Wouldn't you want someone to be able to make medical decisions on your behalf? That's what a healthcare proxy does. That's a document that you will need. It allows you to name someone you know and who cares about you to give instructions and permissions to medical personnel if you are unable to do so. This is often the first part of estate planning because it's the easiest to implement. Your doctor may even have these forms available for you. For instance, if you're getting ready to go into surgery, there's a question that the doctor may ask is if you have something called a proxy. While you're thinking about the possibility of becoming incapacitated, and I promise you once you get these documents signed, you won't have to think about it anymore. Also consider your financial and business dealings. Who would pay your bills? Who would transact business? If there's no power of attorney, no one would. This is another thing that's easy to cross off your to-do list. Sign a power of attorney appointing someone you trust to manage your finances in the event you are unable to do so. Oh, and by the way, let me say this one before we move forward. The power of attorney dies at your death. So it is no longer valid when you die. Take a moment right now and think about what would happen if you died tomorrow. Would your family know what to do first? Would they know who to call? Would they know where your important papers are? Do you have pets that need to be taken care of? Would they know what kind of funeral arrangement you might want? Death of a loved one is always a shock to the family, but you can make it easier on them by writing out a letter of instructions. This will not be a formal legal document, but it's an important part of estate planning because it expresses your wishes about miscellaneous things that may even include expressions of love and gratitude. You could also make a video. I see a lot of that's being done today. The laws governing property ownership and property transfer are meant for your protection. After death, there will be a freeze on your assets so other people can't come in and take them before everything is sorted out. Depending on how your accounts are titled and other estate planning measures you have in place, this could mean that the people closest to you will not be able to access assets until the law says they can. Worst case, your surviving spouse might not even be able to get money out of the ATM. Let's say your money is in a joint account and your surviving spouse's immediate cash needs would be met. Well, what about their ongoing needs? Will your surviving spouse have enough assets to carry on uh, and live comfortably? Will those assets be positioned in a way to generate sufficient income for the rest of their life? For married couple, estate planning needs to span 2 lives. These laws of successions we talked about will kick in and decide who will get your property after you die, or rather, what will happen if you don't intervene and effectively override the laws. Here is a chilling example. You know, the deep voice, Barry White. He died in 2003. He was separated, but not yet divorced. In the eyes of the law, he was still married. So his ex-wife got everything, even though they were separated. His living girlfriend of several years and 9 children received nothing. This is why estate planning starts with a basic knowledge of the law. Who will get your property if you die tomorrow? Even if your situation isn't as dramatic as Barry White's, you may want to finesse the distribution of your assets. Maybe you want some to go to the grandchildren. Maybe you have a friend or some other non-relative that you like to leave money to. Maybe you have charities that you like to continue to support after your death. There are so many ways to design an estate plan, and nearly all improve upon the laws of successions as they were written by your state legislature. Now, that the estate tax exemption is over $12 million, $24 million for couples, but in 2025, that amount may go back down to maybe 5 million or even less. People have gotten complacent about estate taxes. Jack can't cook, by the way. His son, John Cook, no longer could hold ownership to the Washington football team because John had to pay estate taxes. So he had to sell the team in order to pay the estate taxes. And that's something that happened in our region, and we are living with it right now. If you die tomorrow and all of your assets total less than the exemption, now 12 million, there will be no estate taxes. But there are 2 things to say about this. First, the exemptions amounts, as I said, are scheduled to go back to 5 million, $10 million for couples in 2026. If you continue to procrastinate, and if Congress doesn't extend the current exemption amounts, your estate could be subject to estate taxes. The other thing is that estate taxes are not the only taxes to worry about. Some states impose their own estate taxes with lower exemption amounts. Some states impose inheritance taxes on the heirs. Maryland is one of them, by the way. Also, if you'll be passing on an IRA, your beneficiaries may have to pay income taxes on that distributions. These taxes usually can't be avoided, but they can be reduced or deferred if managed right. Another big part of estate planning is preparing your beneficiaries for their new responsibilities. Will they know how and when they must take required minimum distributions from their inherited IRAs? Will they know how to manage this new pool of assets? Traditionally, estate planning was done in secret. This was partly because no family wants to talk about death. It was also because the patriarch or the matriarch didn't want to start any family squabbles. better to let things happen after they're gone. But today, modern form of estate planning is much more transparent. Parents want to help their children. Adult children often know how much of an inheritance they can expect to receive. And this gives them an opportunity to prepare for it. At the very least, you can introduce your kids to your financial advisor so we can start planning together. Then when the time comes, your children will have somewhere to turn to, and we can help them get on with their RMDs and things of that nature. Okay, let's say that you have an estate plan in place. You've seen a lawyer and had all the necessary documents drawn up. It feels good, doesn't it? I can tell you from the experience from my clients who've done their estate plans, it feels like the weight has been lifted from their shoulders. They know that their affairs are in order and their wishes will be carried out after they're gone. If this is you, congratulations. Now I have to tell you that the job is never completely done. As you move through life and as your financial situation changes and your family composition changes, your estate plan will need updating. We talked about the sad story of Barry White, whose ex-wife inherited his estate to the exclusion of his living girlfriend and their 9 children. There's also the story of Heath Ledger, whose 2-year-old daughter was left out of his will because he never updated it after she was born. Instead, everything went to his parents and 3 sisters. This story has a happy ending because Heath Ledger's family gave the money to Ledger's daughter, but not all families are so fair-minded. Also, sometimes people do their estate plans but fail to finish the job. Michael Jackson created a revocable living trust designed to transfer his wealth to his children and his mother when he passed, but he never funded the trust. Instead, his entire estate was left outside the trust. The estate had to go through probate process while Jackson's children and his mother lived off an allowance managed by the estate's executor and a judge. This went on for years. During the probate process, the estate faced numerous legal challenges from creditors as well as the Jackson family. Now let's look at some of the situations that may call for updating your estate plan. How much has your house appreciated in value since you did your estate plan? How about your retirement accounts? Even if you're still under the federal estate exemption amount, an increase in assets could call for a different strategy, different tools, and different decisions about who gets what. Yes, I know what you're thinking. The sagging stock market has left many of us fewer assets than we really had in the beginning. Reduced assets also may call for different plans. Maybe you're not feeling so generous today. Perhaps a gifting program you set up seems a bit unaffordable today. Remember, estate planning is not just transferring assets after your death. It's all about ensuring lifetime income for yourself and your spouse. If your assets have fallen in value, you may want to revisit your estate plan. Children do grow up. That minor child you provided for in your will now be well past the age of majority. These young adults you once thought couldn't handle a large pool of assets may be now grown up and perfectly capable of handling an inheritance. Or maybe your adult children are in a place of life where they can use part of the inheritance now. If they need money to buy a house or business, and if you can afford it, why not help them? Lifetime distributions are also part of estate planning. And you get the satisfaction of seeing the money put to work by the people you love. Have there been wedding bells in the family since you did your estate plan? Have you welcomed a new son or daughter-in-law? This new union also has legal ramifications with respect to your daughter's or son's inheritance. Even if you have welcomed your new family member with the open arms and are happy to share the wealth, your children's new marital status requires a fresh look at your estate plan. The birth of a child always requires an estate plan update. Even if your will or trust was written to include grandchildren not yet born, so as not to unintentionally disinherit them, you'll want to bring your documents up to date to name the new child and make other necessary revisions. If you have recently gotten divorced or remarried and haven't updated your estate plan, we'll excuse you while you go to your attorney right now. This is one of the biggest estate planning blunders of all. Keeping an ex-spouse as beneficiary on a life insurance policy or a retirement plan, or even a will or trust. People who have gone through a divorce are usually so tired of dealing with lawyers that they put off updating their estate plan, figuring they'll take a little break and do it later. Then they'll never get around to it. Tragic. Or what if you have a new spouse? This new union brings its own legal consequences. If you have children from a former marriage, you'll want to balance everyone's needs and make sure your estate planning documents reflect that. We're not here to tell you how you should plan your estate. Some of these decisions can be difficult and complicated. We're just here to remind you that if you don't update your estate plan following certain legal events, such as divorce or remarriage or things like that, disaster could occur. Proactively is what we like. If you haven't made a move yet, but are thinking about divorcing your current spouse and or remarrying a new spouse, please put your estate plan front and center. Remember, until you actually divorced, you are considered married in the eyes of the law, because it may be difficult or impossible to remove a soon-to-be ex from certain accounts while you're going through a divorce, and because certain estate planning changes can complicate divorce proceedings, you need to consult with both your divorce attorney and your estate planning attorney. If you're thinking of remarrying, you may be advised to get a prenup. People have different opinions about these, so we'll just have to put it out there and let you and your lawyer decide whether or not it's right for you. Yes, tax laws have changed, and they will change. They will continually change. I have another briefing that I do talking about the new Secure 2.0, which is about tax laws and its relationship to retirement income. So you need to understand what could happen to your money, even when it's down the line, several years down the line. And unless you are a lawyer, you might not know which laws may affect your estate plan. Most good lawyers stay in touch with their clients and notify them when their estate needs to be reviewed in the light of new law changes. And maybe the lawyer who did your estate hasn't kept in touch, or maybe they did, but you ignore their communications. Whatever. It is very hard for ordinary people to keep up with tax law changes. I do it because I'm a tax accountant. I have to keep up with the tax law changes, but it's a daunting task. I have to attend classes all the time just to keep up with the laws that have changed in the last 4 or 5 years. For one, when you're getting your information from the news, there can be some confusion over which laws have been passed and which laws have been proposed. Among the laws that have passed, it's sometimes not clear what the effective dates are. And some laws are so complex and arcane, it's important It's impossible for an ordinary person to understand their effect. I get calls all the time, people thinking about writing off their house or writing off their car, and they don't even have a business. They just think you can do that. For example, the laws governing all different types of trusts are nearly impossible to understand without a deep understanding of how these trusts work in the first place. One of those trusts could now be perfect for your circumstances, but you would never know it without an estate plan review. I'll just say that it's been a little bit more than a couple of years since you've had your estate plan review. It's probably time. Tax laws will continue to change without a doubt. 2025, the present tax laws that we have now will change because of the way it was written to expire. So 2026, we will look at some new taxes no matter what. As politicians come and go, we can count on new legislation ever so often to undo the first round of changes. Also, because many of our laws are due to sunset at a specific time, we know the laws will change. We don't know if Congress will allow the laws to sunset, which means things will go back the other way as they were before, or, well, it will pass different legislation before the sunset occurs. And it depends on whether the Democrats are in power or Republicans are in power. All we know is that laws will be different in the future. Estate planning lawyers have their work cut out for them trying to draft documents to accommodate changing laws when they don't even know what the new laws will be. But frequent reviews and revisions can help you stay on top of things. And remember, what matters is what laws are in effect when you die, not at the time you draft the documents. Let me say that at a time. What matters is what laws are in effect when you die, not at the time when you draft the documents. So you have to be careful about, planning for the future. Many of the laws governing estate planning are state laws. Now, some estate planning documents can carry over from state to state, but some need to be drafted anew to comply with a new state's requirement. And there may be some different laws in the new state that point to a change of strategy. Bottom line, if you have moved to a different state once you had your estate plan done, make an appointment with an attorney in that new state for a thorough review of your estate plan. You won't be around to watch, but your executor or successor trustee will be very busy after you die, rounding up all of your assets, accounting for everything, and eventually distributing them to the beneficiaries you have chosen. While you're alive, you want to keep tabs on this person. Presumably, you've chosen someone close to you whom you trust implicitly. It could be an adult child, a family friend, or a trusted professional, preferably someone younger than you. You also may have named a successor executor or trustee to step in if that first person isn't available. Keep tabs on these people. If you discover that the person or people you named are not able to do the work of administering your will or trust, you need to name somebody else. You've changed your mind about where you want your assets to go. This happens. In fact, one of the reasons people put off doing their estate planning is that they can't exactly decide whom they want to inherit their assets. It's okay. These can be hard decisions, but it's better to take a stab at it than not to have an estate plan at all. Your will or trust can always be revised if you change your mind. If you've forgotten who you name as beneficiaries, it's definitely time to update your plan. Pull out the documents and read what's there. Is it what you still want? Have you changed your mind about anything? Especially in light of some of the things that we've talked about with the new family members and change in marital status and things of that nature. If so, it's time to update your plan. Preparedness is the antidote to fear. This is the famous quote that applies to many areas of your life. Some people fear death because they worry about what will become of their loved ones after they're gone. Your family will miss you, of course, but with a solid estate plan in place, at least they won't have to wonder what you would have wanted and can help make sure your wishes will be carried out. Your estate plan will all about stating your wishes, but really, you're doing it for them. Taking the time and trouble to get your affairs in order is one of the loving things that you can do while you are on this earth. I hope this presentation has opened your eyes to some of the issues surrounding estate planning. What I like to do now is to sit down, call me. I have an estate planning assessment tool to see whether or not you have done what you need to do. I've also have arranged with attorneys so that they can do a review. I'm trying to talk to one attorney so that he could reduce the price of his review. They charge, this one particular attorney charges $750 just to review your estate plan. A trust document, revocable trust, will probably cost the minimum price I've seen in this area is around $4,500 to $5,000, upwards to about $6,000. So that's why you have to do this right. So give me a call so that I can kind of set you up for an assessment, and then I can determine which way you need to go to see whether or not you need to, sometimes you just need a will, the 5 documents that you need for health and all those healthcare directives and things of that nature. And sometimes you need a full-blown trust document. And it would depend on that will help me to determine which kind of an attorney you need to see. So whether or not you are doing your estate plan for the first time or have questions about your estate plan, the J.E. Henderson Financial and Henderson Tax and Business Services, we're here to help. So that concludes my presentation for this evening, and I encourage you to think about what is going to happen when you depart this earth.
It just says IRA question mark.
IRA, individual retirement account. Usually you can have one, about 3 different types. One when you're working that requires if the company that you work for has a retirement plan, you're only permitted to have so much into an IRA, individual retirement account. Also, when you do have a 401k at work or 403b or 457 plan at work, once you retire, you may want to roll that money over into an IRA so that it could still have the tax deferred status. And so that document you could put it into an annuity or some other instrument like that, and it still retains itself as an IRA, whether or not it's in an investment account, but you have to specifically name it as an IRA. And then once you die, there are some specified rules which just changed this past January, that if you receive money from an IRA, that person will have to empty out that bucket of money in 10 years, so that you have to pay taxes on it. So I'm hopeful that answers the questions about IRA.
And we have another question that says, at a certain age, do you take the money out?
Okay, so that rule is changing as well. In the past, you may have heard the age 70 and a half. Well, 2 years ago, that rule changed to age 72. So right now we are at the 72-year period. In 2033, the new age will be 73. So once you reach that age, Uncle Sam requires you, and that's called RMD. You may have heard me use the term RMD, and it means required minimum distribution. And this is what I normally talk about when I talk about insurance, is that the deferred compensation plans like 401ks and 403bs, that's the term is deferred, not free. So the Uncle Sam will, at age that I talked about, age 72 or 73, will force you to take money out of that account, so that you have to empty out the money prior to your death. So what I'm trying to get clients to do now is not to put all their eggs in the IRA basket or the 401k basket, is to buy life insurance, and life insurance will be tax-free. They must have a better lobby than some of the other companies, because it always has been tax-free, and life insurance is a contract and not by law. So if you bought one earlier and they happen to change the law, they won't, because it's a contract legally, they can't change what the life insurance policy that you bought. So life insurance is an addendum, it's an additional part of retirement planning. And also, when you leave money through a life insurance policy, your beneficiaries will also receive the money tax-free. So as far as an estate planning tool, I encourage my clients to use life insurance instead of IRAs and things of that nature. I mean, there's a need for both kinds of products, but I try to get people to think about tax literacy when they're looking at retirement and legacy planning.
We have one more question. It says at 72, if you do not take out the money, what happens?
Well, in the past, there used to be a 50% penalty. With the new tax law, they've decided to reduce that penalty down to about 10 to 15%, I think it is. If you don't do it, let's say you forgot. Let's say you had an IRA and you just forgot about it, and that happens to a lot of people. They just got money, they don't know they don't even know what is there, and until the custodial company realizes that you haven't, taken money according to the rules, and it may go on for years. I had a client who was in his 90s, and he had not taken out any RMD, and I had to go to the IRS and beg the IRS not to take 50% penalty, because he was in his 90s and he was frail and he just didn't know. So we had to basically what they had to do, I had to go back and redo his taxes for that period of time that he should have taken money out, and he just had to pay the taxes on that money. But it was really a pretty bad situation, because he was in a nursing home when he did it. I mean, when he found out. So the government took most of his money right away. I appreciate the opportunity to give you some information